So this presentation's going to look at the Human Rights Act and entitlements, particularly around death by suicide whilst in the care of the state. The Human Rights Act of 1998, all persons have the protection of the Human Rights Act. In addition to this, children have 54 articles of entitlement under the Convention on the Rights of the Child. The Human Rights Act for all persons are as follows: the right to life, the right to prohibition of torture, the right to prohibition of slavery and forced labour, the right to liberty and security, the right to a fair trial, the right to no punishment without law, the right to respect for private and family life, the right to freedom of thought, conscience and religion, the right to freedom of expression, the right to freedom of assembly and association, the right to marry, and the right to prohibition of discrimination. Now you'll notice at the end of each line there's either an A, an L or a Q, and that stands for either absolute rights, limited rights or qualified rights. In relation to absolute rights, so highlighted in yellow, we've got the right to life, the right to prohibition of torture, the right to prohibition of slavery and forced labour, the right to no punishment without law. Absolute right means that this right cannot be restricted by the interests of the community as a whole. Absolute rights are those that cannot be infringed, rights that the government and agencies must uphold in all circumstances. So looking at limited rights, we have the right to liberty and security, the right to a fair trial, the right to marry, and the right to prohibition of discrimination. Limited rights do not apply in all circumstances. For example, the right to liberty, if arrest and detention is lawful, may be affected by national security, interests of morality, interests of young people under 18 years. So let's have a look at qualified rights. So these are highlighted in green: the right to respect for private and family life, the right to freedom of thought, conscience and religion, the right to freedom of expression, the right to freedom of assembly and association. Qualified rights relate to matters where interference by the public authority is permissible if it's in the public's interest and can be qualified, for example, for the prevention of crime, public safety and national security. Convention rights of the child then. So we've just selected some of these to look at, but a convention is a treaty or legal instrument, an agreement in international law between countries. The UN Convention on the Rights of the Child is a wide-ranging international treaty of articles defining the rights of children. Article 3, for example, relates to the best interests of the child, and a child being a person up to the age of 18. The best interests of the child must be the primary concern in making decisions that may affect them. All adults should do what is best for children. Article 6, survival and development. Children have the right to live, survive and develop healthily. Article 8, preservation of identity. Children have the right to an identity. Article 12, respect for the views of the child. When adults are making decisions that affect children, children have the right to say what they think and feel and have their opinions taken into consideration. Article 15, freedom of association. Children have the right to meet together and to join groups and organisations. Article 19, protection from all forms of violence. Children have the right to be protected from being hurt and mistreated, physically or mentally. Any form of discipline involving violence is unacceptable. Article 23, children with disabilities. Children who have any kind of disability have the right to special care and support to live independent lives. Article 25, review of treatment in care. Children who are looked after by local authorities have the right to have their living arrangements regularly reviewed to ensure in the best interests of the child. Article 28, the right to education. All children have the right to a primary education which should be free of charge. Discipline within schools should not include violence and should respect the rights and entitlements. Article 31, leisure, play and culture. Children have the right to relax and play and join in a range of cultural, artistic and recreational activities. Article 33, drug abuse. Article 33 also means that children and young people should be protected from the effects of a parent's drug use and that their lives shouldn't be made more difficult because of it. Article 37, detention and punishment. No child shall be subjected to torture or other cruel, inhumane or degrading treatment or punishment. No child shall be deprived of his or her liberty unlawfully or arbitrarily. Every child deprived of his or her liberty shall have the right to prompt access to legal and other appropriate assistance, as well as the right to challenge the legality of the deprivation. Article 39, Rehabilitation of child victims. State parties shall take all appropriate measures to promote physical and psychological recovery and social reintegration of a child victim of any form of neglect, exploitation or abuse, torture or any other form of cruel, inhumane or degrading treatment or punishment, or armed conflicts. Such recovery and reintegration shall take place in an environment which fosters the health, self-respect and dignity of the child. So what we're going to look at specifically now is in relation to Article 2 of the Human Rights Act and the right to life. Everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. Deprivation of life shall not be regarded as inflicted in contravention of this article when it results from the use of force which is no more than absolute necessary. A, in defence of any person from unlawful violence, such as self-defence. B, in order to effect a lawful arrest or to prevent the escape of a person lawfully detained. Or C, in action lawfully taken for the purpose of quelling a riot or insurrection. Positive obligation then. The court's approach to the interpretation of Article 2 must be guided by the fact that the object and purpose of the Convention as an instrument for the protection of individual human beings requires that its provisions must be interpreted and applied so as to make its safeguards practical and effective. Article 2 enjoins the state not only to refrain from the intentional and unlawful taking of life, but also to take appropriate steps to safeguard the lives of others within its jurisdiction. In broad terms, this positive obligation has two aspects. Firstly, the duty to provide a regulatory framework, and B, the obligation to take preventative operational measures. So, two parts to Article 2. One is that we don't take anybody's life unlawfully, and the second part is that we have a positive obligation to prevent them losing their life. The court has found the positive obligation under Article 2 to take appropriate steps to safeguard the lives of those within its jurisdiction to apply in the context of any activity, whether public or not, in which the right to life may be at stake. The court has held that Article 2 of the Convention implies in certain well-defined circumstances a positive obligation on the authorities to take preventative operational measures to protect an individual whose life is at risk from the criminal acts of another individual, for example, Osman versus the United Kingdom. For a positive obligation to arise, it must be established that the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of the identified individual or individuals from the criminal acts of a third party, and that they failed to take measures within the scope of their powers, which, judged reasonably, might have expected to avoid that risk. For the court, it's sufficient for an applicant to show that the authorities did not do all that they could be reasonably expected of them to avoid a real and immediate risk to life, of which they have or ought to have knowledge. This question, in its view, could only be answered in light of all the circumstances of the case at hand. The court has held that Article 2 may imply, in certain well-defined circumstances, a positive obligation on the part of the authorities to take preventative operational measures, in particular circumstances to protect an individual from himself or herself, so from self-harm. In particular, persons in custody are in a vulnerable position and the authorities are under a duty to protect them, for example, Keenan versus the United Kingdom. Persons with mental disabilities are considered to constitute a particularly vulnerable group who require protection from self-harm. In particular, the authorities have a general operational duty to take reasonable measures to prevent a person from self-harm, irrespective of whether there has been voluntary or involuntary hospitalizations. In this respect, the specific measures required will depend on the particular circumstances of the case, and those specific circumstances will often differ depending on whether the patient is voluntary or involuntary hospitalized. However, in the case of patients who are hospitalized following a judicial order and therefore involuntary, the court in its own assessment may apply a stricter standard of scrutiny. Ultimately, for a positive obligation to arise, where the risk to a person derives from self-harm, such as a suicide in custody or in a psychiatric hospital, it must be established that the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual, and if so, that they failed to take measures within the scope of their powers, which, judged reasonably, might have been expected to avoid that risk. For example, Younger versus the United Kingdom. In order to establish whether the authorities knew or ought to have known that the life of a particular individual was subject to a real and immediate risk, triggering the duty to take appropriate preventative measures, the court takes into account a number of factors, including, firstly, whether the person had a history of mental health problems. Second, the gravity of the mental condition. Third, previous attempts to commit suicide or self-harm. Fourth, suicidal thoughts or threats. And 5, signs of physical or mental distress. Moreover, the court also reiterates that the obligation to protect the health and well-being of persons in detention clearly encompasses an obligation to protect the life of arrested and detained persons from a foreseeable danger. The duty to take preventative operational measures has arisen so far mainly in the following contexts. Firstly, detention in custody or in prison. Secondly, compulsory military service. And thirdly, voluntary or involuntary psychiatric care. In a case where the applicant's wife set herself on fire in protest at a forced eviction, the court held that in a situation where an individual threatens to take his or her own life in plain view of a state agent, and moreover, where this threat is an emotional reaction directly induced by the state agent's actions or demands, the latter should treat this threat with the utmost seriousness as constituting an imminent risk to that individual's life, regardless of how unexpected that threat might have been. In such circumstances, if the state agents become aware of such a threat sufficiently in advance, a positive obligation arises under Article 2, requiring them to prevent this threat from materialising by any means which are reasonable and foreseeable in the circumstances. In the context of industrial activities, which the court has deemed to be by their very nature dangerous, the court has placed a special emphasis on regulations geared to the special features of the activity in question, particularly with regard to the level of potential risk to human lives. It considered that they must govern the licensing, setting up, operation, security and supervision of the activity, and must make it compulsory for all those concerned to take practical measures to ensure the effective protection of citizens whose lives might be endangered by the inherent risks. Whenever a state undertakes or organises dangerous activities or authorises them, it must ensure through a system of rules and through sufficient control that the risk is reduced to a reasonable minimum. If nevertheless damages arise, it will only amount to a breach of the state's positive obligations if it was due to insufficient regulations or insufficient control, but not if the damage was caused through the negligent conduct of an individual of unfortunate events. The court has emphasised the right of all prisoners to conditions of detention which are compatible with human dignity, so as to ensure that the manner and method of execution of the measures imposed do not subject them to distress or hardship of an intensity exceeding the unavoidable level of suffering inherent in detention. In addition, besides the health of prisoners, their well-being also has to be adequately secured given the practical demands of the imprisonment. The court accepts that the medical assistance available in prison hospitals may not always be the same standard as in the best medical institutions for the general public. Nevertheless, the state must ensure that the health and well-being of detainees are adequately secured by, amongst other things, providing them with the requisite medical assistance. The authorities must also ensure that the diagnosis and care are prompt and accurate, and that where necessitated by the nature of a medical condition, supervision is regular and systematic and involves a comprehensive therapeutic strategy aimed at curing the detainee's disease or preventing their aggravation. Persons in custody are in a vulnerable position and the authorities are under a duty to protect them. Consequently, when an individual is taken into police custody in good health and is found to be injured on release, it is incumbent on the state to provide a plausible explanation of how those injuries were caused. The obligation on the authorities to account for the treatment of an individual in custody is particularly stringent when that individual dies. So let's look now at a particular case of suicide in relation to Article 2, the Human Rights Act. And this case is Savage versus South Essex Partnership NHS Foundation Trust 2008. So Article 2, the Human Rights Act, places a positive obligation upon the state to protect life. So in Savage versus South Essex Partnership NHS Trust, the appeal was allowed. It was not necessary to show gross negligence. In order to establish a breach of Article 2 on the assumed facts, the appellant must show that at the material time, the trust knew or ought to have known of the existence of a real and imminent risk to the life of Mrs. Savage from self-harm, and that it failed to take measures within the scope of their powers, which judged reasonably might have been expected to avoid that risk. Act 2 imposes, in addition to general obligations, a further operational obligation on health authorities and their hospital staff. If members of staff know or ought to have known that a particular patient presents a real and imminent risk of suicide, they must do all that can reasonably be expected to prevent the patient from committing suicide. Now, on the 5th of July 2004, Mrs. Carol Savage walked out of the hospital to which she had been compulsory admitted under Section 3 of the Mental Health Act 1983 over 3 months earlier. She walked about 2 miles to a railway station and jumped in front of a train which killed her. An inquest jury concluded that she had killed herself while suffering from paranoid schizophrenia. They also considered that the precautions taken to prevent her from absconding from the hospital were inadequate. So Lord Roger of Earlsferry said that the decisions of the European Court of Human Rights in Powell versus United Kingdom and Osman versus United Kingdom related to different aspects of Article 2 obligations of health authorities and their staff to protect life. The obligations were not alternative but complementary. Under the Powell case, health authorities were required to ensure that the hospitals for which they were responsible enjoyed competent staff and they were trained to a high professional standard. In addition, the authorities had to ensure that the hospitals adopted systems of work which would protect the lives of patients. Failure to perform those general obligations might result in a violation of Article 2. If, for example, a health authority failed to ensure that a hospital put in place a proper system for supervising mentally ill patients and, as a result, a patient was able to commit suicide, the health authority would have violated the patient's rights to life under Article 2. Persons in police custody or in prison are in a different situation. Their personal autonomy has been lawfully restricted by action taken against them by the state. The restrictions imposed may, for some, bring about depression, feelings of hopelessness, and thoughts of suicide. Such a state of mind, if apparent to those who have charge of the person concerned, would constitute, in my opinion, a circumstance highly relevant to the standard of protection required by the positive obligation under Article 2.1. The Keenan test refers to a real and immediate risk to self-harm known or that ought to be known to the custodial authorities. Such a knowledge would plainly constitute a very significant circumstance. Mentally ill patients detained under Section 3 are in a position in some respects similar to, but in other respects very different from, the position of those in police custody or in prison. Their position is similar in that they are detained by law. Some sectioned mental patients may be content with their lot, but others will not be. It appears from the number of times Mrs. Savage attempted to abscond that she fell into the latter class. Their position is dissimilar in that they are detained, as Baroness Hale has said, for the protection and not as a punishment. Nevertheless, the European Court has recognised that, in certain circumstances, the state's duty under Article 2 does indeed include a duty to take steps to prevent people from killing themselves. The court first adopted that interpretation of Article 2 in Keenan versus United Kingdom, a case involving a young man who had committed suicide while in custody in Exeter prison. The obligations on the prison authorities, which the court identified, were adaptations of the obligations which it had expounded in Osman, stating with a high-level general duty and working down to an operational duty. Therefore, the duty of prison authorities to take steps to prevent suicides derives from their wider duty to protect prisoners who are in a vulnerable position and for whom they are responsible. If the authorities failed to put in place appropriate general measures to prevent suicides amongst the prisoners in particularly prison, and as a result a prisoner was able to commit suicide, there would be a breach of Article 2. If, on the other hand, the authorities had employed properly trained staff and taken all the relevant general precautions, but a prisoner nonetheless succeeded in committing suicide because of the casual negligence of a member of the prison staff, the prison authorities would be vicariously liable for that negligence, but there would be no violation of Article 2. The fact that patients are suffering from mental illness is also relevant to the authorities' obligation under Article 2. As can be seen from passages already referred to, the vulnerability of people suffering from mental illness and the consequential need to protect them are themes that run through the case law of the European Court. So, in deciding what measures should be taken to protect the lives of patients in mental hospitals or of patients in general hospitals who are suffering from mental illness, the authorities will have to take account of the vulnerability of these patients, including a heightened risk that may commit suicide. The fact that Mrs. Savage was not only a patient but a detained patient is also relevant to the authorities' obligations under Article 2. I am accordingly satisfied that as a public authority, the Trust was under a general obligation by virtue of Article 2 to take precautions to prevent suicides amongst detained patients in Runwell Hospital. It may be useful to summarise the relevant obligations of health authorities like the Trust and to note the way they relate to one another. In terms of Article 2, health authorities are under an overarching obligation to protect the lives of patients in their hospitals. In order to fulfil that obligation, and depending on the circumstances, they may require to fulfil a number of complementary obligations. In the first place, the duty to protect the lives of patients requires health authorities to ensure that the hospitals for which they are responsible employ competent staff that they have trained to a high professional standard. In addition, the authorities must ensure that the hospitals adopt systems of work which will protect the lives of patients. Failure to perform these general obligations may result in a violation of Article 2. If, for example, a health authority fails to ensure that a hospital puts in place a proper system for supervising mentally ill patients and, as a result, the patient is able to commit suicide, the health authority will have violated the patient's rights to life under Article 2. Even though a health authority employed competent staff and ensured that they were trained to a high professional standard, a doctor, for example, might still treat a patient negligently and the patient might die as a result. In that situation, there would be no violation of Article 2, since the health authority would have done all that the article required of it to protect the patient's life. Nevertheless, the doctor would be personally liable in damages for the death, and the health authority would be vicariously liable for the negligence. This is the situation envisaged by Powell. The same approach would apply if a mental hospital had established an appropriate system for supervising patients, and all that happened was that on a particular occasion a nurse negligently left his post and a patient took the opportunity to commit suicide. There would be no violation of any obligation under Article 2, since the health authority would have done all that the article required of it. But, again, the nurse would be personally liable in damages for the death, and the health authority would be vicariously liable too. Again, this is just an application of the case of Powell. Finally, Article 2 imposes further operational obligation on health authorities and their hospital staff. This obligation is distinct from and additional to the authorities' more general obligations. The operational obligation arises only if members of staff know or ought to have known that a particular patient presents a real and immediate risk of suicide. In these circumstances, Article 2 requires them to do all that can reasonably be expected to prevent the patient from committing suicide. If they fail to do this, not only will they and the health authorities be liable in negligence, but there will also be a violation of the operational obligation under Article 2 to protect the patient's life. This is comparable to the position in Osman and Keenan. As the present case shows, if no other remedy is available, proceedings for an alleged breach of the obligation can be taken under the Human Rights Act of 1998. And that's the end of that presentation.